So, my name is Shazia Khan, and the unit we'll be doing today is Introduction to Law and Practice. And it's a level 3 unit, and it's 20 credit points. So I'll go through the specification with you first, so you've got a little bit of an idea of what we're doing. Okay, so for the unit, the grading is a pass or a fail, so you'd either get one or the other. And the unit aim is to introduce students to the basic concepts of English legal system, as well as the UK's relationship between the EU and changes because of Brexit. You know, when Brexit came in, there were lots of changes.
Yeah.
Students completing this unit will be provided with a grounding in basic concepts of English law and the foundations of law. And we'll be looking at elements of that. There's there's 4 learning outcomes and an assignment discussion. So the first, I'm not going to go through the assessment criteria because throughout the sessions we'll go through that, so you'll have a more of an idea, so it's clear to you. Firstly, you've got the learning outcomes, which is one, which we're doing today, is to understand the structure of the English legal system. The second learning outcome is to understand how Parliament passes an act. And the third one is to understand the hierarchy of the courts, so different structures of courts. And then the fourth learning outcome is to understand the roles in the legal profession, so things like juries, barristers, solicitors. Um, and then we'll have an assignment discussion, and you'd either have to meet all the learning outcomes to achieve the mark of a pass for the assessment, and the word count for the coursework is 2,500 words. Okay, when it comes to doing the assignment discussion, which is after all of the 4 units, 4 learning outcomes, then I'll give you a better idea of what you need to do in the assignment, but I will show you the assignment brief as well. Okay. So the indicative reading list is English Legal System by Emily Alban and Samrit Kaur, and the English Legal System by Slapper and Kelly as well. So there could be some extra additional resources on Moodle that you could get as well.
Yeah.
So have you got any questions around the module specification? Now, this is available for you on Moodle, so you don't need to really be asking to email this. It's all on Moodle on
Okay.
you've got on it. I'm just going to show you quickly the assignment, and then I'm not going to go through it because we need to go through the assignment discussion will be done in the last week, okay?
Okay. Which
So
one does this finish? The
what's
whole
that? Sorry.
course? When do you finish the whole course?
So you've got today, tomorrow, next weekend, and the weekend, one weekend after. So it's only
Oh, okay.
5 days that you have to do it. That's
Oh,
only
okay.
this module though. That's only this unit, okay?
Oh, okay.
So the other units you'd have to discuss with the rest of them to see when you can do them.
Oh, okay. He did say, Amandeep did say I could do them online if I wanted to.
Oh, did he?
Yeah. So
Oh,
they'll
okay.
send me a recorded a video of you doing this, and I can just
Yeah,
go through it
you
on my
you could
own.
speak to Amandeep, but it's best to get one unit out of the way so you could do the
Yeah.
assignment and then carry on with the next units.
Oh, okay. Yeah, that's fine.
Yeah, but speak to Amandeep about this, okay? So
Okay.
so this is the assignment brief. This is available on Moodle for you, okay? So the assignment aims are the same, the units, learning outcomes are the same. Then you go there, you've got 2 tasks in this and it goes through each one. But I'm not going to go through it now with you because when we do the assignment discussion, I'll go through it in detail and where you can
Okay.
get the answers and things like that, where you can look for
Mm-hmm.
extra resources. So this is again available on Moodle for you, okay?
Okay.
But if you've got any questions, just ask Ammon as well if you need to refer to anything, okay?
Mm-hmm. Okay, I will do. Yeah.
So let's go on the first session. So the first session we're doing is learning outcome 1, okay? And it's to understand the structure of the English legal system, how it works, why there's that structure in place, how the court systems work, and why we have this, difference between the areas of law as well. The unit aim is to introduce students to the basic concepts of English legal system, as well as the UK's relationship between the EU and changes of Brexit. So you're going to look at the foundations of the English legal system.
Uh,
The indicative content for learning outcome 1 is to look at the introduction to the law historical developments, how the law was developed, because that's really important to look at how law was developed before we can identify areas of law, equity and how it works in the legal system, the concept of criminal law, civil law, a burden of proof, and balance of probabilities. We look at common law and precedent. We look at the legislative, the executive, and the judiciary, what their role is within the UK, and how it fits to provide the function of the UK Constitution, and how the EU impacted on the UK as well. Sorry, I've got a bit of a cold, so if I do sneeze or anything, it's just because I've got this really bad cold as well.
No, it's fine.
So the key terminology, so the English legal system, it consists of things like statutes, we have common law, we have equity, and we relied on these historically, so it was developed over time. You know, we had equity, which was the principle of being fair, and then, you know, you've got common law, which was declared by judges, but it was derived by precedent. Precedent means case law. So we relied on that historically in the 12th century, and then equity came about because there was only one remedy available in common law, so equity was needed to make sure that, you know, nobody suffered. Then the key terminology for criminal law is offence against society as a whole, and its main aim is to protect elements of public order and safety. And then civil law is the relationship, you know, between individuals, you know, how they work together and how that relationship is formed. And it's normally in the form of, for civil law, you tend to get compensation in the form of it, whereas in criminal law, you'd get a sentence. So there's a video here which you can watch in your own time, and this video is on the English legal system, and it's about a 9-minute video, and it looks at the element of how the English legal system works. So look at this in your own time, okay?
Okay.
So the legal structure of the UK is based on a hierarchy of laws and sources of law and common law and courts, institutions, principles, the rule of law. You know, it's based around the different types of laws in place, and you know, things like common law, which is unwritten, or case law, a statute law, which is passed by Parliament, and the main Parliament is the main supreme making body, lawmaking body. So what does that mean when we talk about Parliament is the supreme lawmaking body?
Um,
Does it mean that Parliament makes the law?
I mean, yeah, they
Yeah,
decide.
yeah.
Yeah, they
And do we
decide
have
the
to
law.
follow that law?
Yeah.
Yes. In this country, we have to follow that law. Whatever law Parliament passes, we have to follow that. And then your rule of law is everyone, including the government, is subject to law. So that's equality of law. You know, the rule of law means being equal with everyone.
Yeah.
Because, you know, if we're not equal, like for example, the rich get, you know,
Yeah,
more.
they get more than us. Yeah.
Yeah. So equality, the rule of law is really important in any sort of element of law.
Yep.
So then we look at the sources of law. The sources of law are the foundations from which legal rules and principles emerge, primarily things like in that list, statutory law, case law, and customary law. Statutes, as we said, are enacted by legislative bodies. Cases are consist of judicial decisions, so judges made decisions. And then you've got, you know, legislation is passed by Parliament. So it's the main thing that Parliament has to pass that we have to follow. You know, laws that are placed. Common law, again, is precedents established by judicial. These are things that are developed through history and where courts must follow. So, for example, if there's a case on rape, that was a huge case historically, yeah, in
Yeah.
common law, then if it's very similar to a case today, can we follow that?
Um, I know, I don't
To
think
help
so.
us,
'Cause we
can
just,
judges rely on that?
no, because we've got new rules now. They
Yeah, but
changed.
the rules might be the same, so you could rely on them.
Oh, okay,
If the
yeah.
rules and laws are the same, then you could rely on them. But if they're not,
Okay.
then I understand what you're saying. But if that's why, you know, if there's a case on, for example, a case on theft, and it
Yeah.
was a similar case happening now,
Mm-hmm.
rely on previous precedent, previous cases to help us come to a decision.
Oh, okay, yeah.
Yeah, and it's really important previous cases because judges rely on them quite a lot. And then we've
Yeah,
got the European Union law, which is retained at the moment, and that's when, EU laws remain. We're not part of Brexit, but EU law still remains. And then we've got the European Convention on Human Rights. It's in the UK, it's via the Human Rights Act, and the European Convention on Human Rights is to try to protect people against human rights issues. And then we've got customary traditions and practices that have legal recognition. Over time, practices have developed, over tradition, practices have developed that we follow to help us come to a decision.
yeah, yeah.
So then you have a hierarchy of courts. Why do you think it's so important to have this hierarchy of courts?
I think it just sets out the on how and what to do in the
Yeah.
court.
Do you think different cases are dealt with by different courts?
Yeah.
And do you think that's a good thing?
I mean, there are different stages of every court, so like maybe it is a better thing.
I think it's a good thing, yeah, because I think,
Yeah,
it helps you, identify what level the court is at, and
yeah,
what the decision are. So, for example, you've got things like in the criminal courts, you've got the element of the magistrates' court that deal
yeah,
with, like summary offences
yeah.
and then they refer them to the Crown Court, who deal with
Oh,
more
okay.
serious cases.
Mhm.
So these are transferred from the Magistrates' Court to the Crown Court to deal with more serious cases. And then they go to the Court of Appeal, which is the criminal division. They go there if they're more serious.
Mhm.
And these here, the criminal division, the Court of Appeal criminal division, actually deal with hearing cases from the Crown Court on points of law or sentencing. And then the highest court in that is which was set up in 2009, is the highest court in the UK, is the Supreme Court. And that hears appeals from the Court of Appeal and the High Court only in exceptional circumstances. So not all cases go there. And then
Yeah,
we've got the civil courts, and the civil courts are a little bit different because obviously it's a civil matter more than a criminal matter. The county courts is the first one, which deals with all except the most complicated and the most simple civil cases. And these are matters that are under £5,000. And then
okay, yeah,
you have the High Court within them, and they have the divisions within the High Court. You've got the Queen's Bench Division, you've got the Chancery Division, and you've got the Family Division, and that's within High Court. And these are elements of where they will be dealt with within the High Court.
yeah,
And then you have the Court of Appeal, and they hear appeals on the High Court and tribunals, and the Supreme Court, again, the final court. You also have specialist courts, and these specialist courts are only dealt with in specialist circumstances. So what happens is specialist courts can be specialist in a different area. For example, you might have a specialist court in employment law. You might have a specialist
yeah.
court in immigration law. Because they're specialists in that area, they will be used for that area only.
Oh, okay, yeah,
So it's really good to have, like you have immigration court, but they will only deal with immigration matters. You have like,
yeah,
benefit court, like social security tribunals, and their specialist courts as well will only deal with specialist matters.
yeah,
And then you have the roles of key legal profession. You have judges, you have barristers, solicitors, and legal executives. And each individual one has a different role. They all do
yeah,
different things. So you've got the first one, the judge, obviously, both solicitors and barristers may be appointed as judges. So they ensure that the cases are dealt with properly and the law is applied to make sure everything is fair in any sort of circumstances. Then you have
yeah.
barristers.
Can
So
I just ask, um, to be a judge, what do you need to study? Do you need to be a
what
solicitor and a
was that,
barrister
Sam? I
too?
can't hear you.
Yeah, sorry, can you hear me now?
A little bit, yeah.
I'm saying, to become a judge,
Yeah.
what do you need to become first? Do you need to become a solicitor, a barrister, or is there a different degree for that?
You'd have to be a barrister or a solicitor first if you became a judge.
Okay.
You could be
And what do you do
appointed, but
after that?
you need, I think it's over 6 years of experience as a
Wow.
barrister
Okay.
and a solicitor before you can become to apply for a judge. They can be
Oh,
appointed as judges, but it's more likely that barristers are appointed as judges, but they need a sufficient amount of experience as a barrister first.
okay. Okay. That makes sense.
You can't just become a judge. You need, obviously, to become a judge to have some experience in that kind of area.
Yeah.
So barristers are legal advisors and courtroom advocates, and they put their legal arguments to judges, magistrates, and juries, and they also cross-examine witnesses and otherwise attempt to sway the outcome of a court case. Barristers typically have no direct contact with the public, so barristers are appointed and instructed by solicitors. They don't have any
Oh,
contact with the outside world because they're self-employed. Then you
mm-hmm.
have
Okay.
solicitors who work in different departments, and they instruct barristers. So solicitors, they provide expert guidance on issues such as it could be buying and selling houses, it could be doing a will, it could be protecting, any sort of criminal offences, it could be representing someone in court as well. And then you've got legal executive, and they can be, a chartered legal exec, and they work in the office. They can qualify as a solicitor after the training is done, but they have their own clients and they can represent in court as well. The legal executive has to do, study at the same level to become a solicitor. They're just below a solicitor.
Oh, okay, Miss. What do you need to study after? Obviously, like now, let's say I'm doing level
What's
three.
that? Sorry, Sabbath, I can't hear you.
I'm saying that after doing a level three, I'm gonna do 3 years in uni. To
Yeah.
become a solicitor or a barrister, is there another exam for that?
You'd have to do your degree. Okay, so you do your
Okay.
level three, four, 4, 5, 6, and then you would apply for the SQE,
Oh, okay.
and then
Mm-hmm.
you could do that 1 year full time or 2 years part time, and that would be either to become you do the bar to become a barrister and the SQE to become a solicitor. So it's not really a
Oh,
short route; it's quite a lengthy route, but it's worth
oh,
it.
okay.
It's
Mm-hmm.
worth it at the end.
Yeah.
It's worth it, yeah. Then you have the next one, which is alternative dispute resolution, which is ADR. And there are different ways people can resolve disputes without going to court. So common ADR processes include things like mediation, arbitration, and neutral evaluation. So it's less formal, so it could be resolved without going to court. Criticisms of the challenges, the system can be difficult for people to navigate. It's a very expensive as well, and there's a lot of backlog at the moment. Courts are quite full of cases, but also not everyone gets legal aid, and there's loads of prisons that are full at the moment, which you may have watched on TV.
Yeah.
In conclusion, the legal system is designed to protect and any sort of systems in place, but also, uphold the judicial system, and the court structures are there to help people identify what court structures apply to them. So the next one is looking at elements of 1.1, which is difference between civil and criminal law. So the difference between civil and criminal law is that the fact that, civil law is shaped by case law and criminal law is codified by examples such as the Theft Act that they've given here. And they develop historically quite far back, and the whole point is civil law involves compensation and financial agreements, whereas criminal law involves things like prison sentences, fines, or community service. And criminal cases are usually filed by the government, whilst civil cases are filed by private parties. So the difference is, if you look at the civil law, the purpose is it resolves disputes between individuals in the diagram. The parties involved in civil cases is the claimant, which is referred to as the plaintiff, and the defendant. And the standard of proof is balance of probabilities, more likely than not. The outcome is in civil cases, like I mentioned, is remedy. It's like compensation, injunction orders, or orders. Examples could be areas of law such as contract, dispute, tort law, negligence. The court system is county court and the high court, and the legal representatives is both. In civil cases, both barristers and solicitors can represent you, and they don't have any public focus. And then in criminal law, you've got the maintains public order, so punishes people for what they're doing, make sure, if you pinch a bike or something, you are punished for that. Prosecution, which is the state against the defendant, and the beyond reasonable doubt here. And the punishments are like fines, imprisonment, or community service. And the murder, theft, drug offences are examples of criminal cases. It's at the Magistrates Court and the Crown Court, and the prosecution is held by CPS. And the public interest is high focus on protecting society and trying to prevent any sort of crime happening. So in civil law, the case example they've given is the House of Lords case of Donoghue and Stevenson, where it found that the element of duty of care was established in this, and how a reasonable care of skill performing a duty of care. So this was the main case that dealt with that. Then you have the example of the R and Dudley case in regards to criminal law, and the element of here, it identified moral and legal boundaries to criminal acts. So here was the defence of necessity was not available as a defence for murder, and it was not possible to justify the killing of one individual in order to save the life of another. So this is a really famous case in regards to criminal law. So in conclusion, civil and criminal law form the backbone of any sort of system. So, to have this difference, they've all got their difference, their distinct features. They have their distinct features. They have their distinct elements of how they work and how they work in regards to it. And also the fact that, they are different. They are not the same. Both civil and criminal law different. Civil law is more for compensation, and criminal law is more for punishing someone for wrongdoing. Hello?
Sorry, I don't know
You
what
on? Did it go off again?
Yeah.
It's okay, you are now. So the next one is looking at the organs of the state. Okay, so there are three main organs of the state. We've got the legislature, judiciary, and the government, which is the executive. And we look at each one so you've got a bit of an idea what each one does. So the organ of the state, the first one is the legislature, who creates the law and government activities. Then the second one is the key components is Parliament and House of Commons and House of Lords. And then you've got the executive, who implements and enforces the law, which is the Prime Minister and Cabinet. And then you've got the element of the judiciary, who interprets the law. Things like the judges, they interpret the law in court. And they are the ones that will take on board, what the court says to ensure that there's any sort of justice in regards to that. And that is judges and courts and things. So the legislature, next slide. The legislature is Parliament. It consists of two bodies, which is the House of Commons and the House of Lords. And their function is drafting, debating, and passing law. And then you've got the executive, and that's led by the Prime Minister and supported by the Cabinet. And that is proposing legislation, any sort of legislation, and it is implementing the laws and representing him. And then the judiciary, who's independent and would look at their functions in regards to how they pass the laws. So, like we said, the legislature, sorry, if we go back to that. The legislature is Parliament and the House of Commons. The executive, again, is responsible for creating policies, and then you've got the judiciary, which is the lawmaking body. It comprises of judges and the courts and the law, and it is independent, so they don't listen to what the executive and everyone says, because they have to pass the law fairly, don't they? They can't discriminate or anything. And then you've got the European Union. Now, the European Union was there to integrate economies and prevent any sort of conflicts. And we joined the EU in 1973, and the reason we joined is to try to get this, this kind of founding family together, and make sure, we have this element of creating this European Union. But then we opted out as well. So the European Union, 27 member states, and it was there to facilitate and free movement. So we were allowed to travel. We had, without any restrictions, established common law, trade, trading between each other. We're no longer allowed to do that because of the issue that we opted out. What do you think of that? Do you think it was good that we opted out of the EU?
I mean, I think yeah, it was good. I think it was good,
Do you
but
think it's good?
yeah, but now looking at the stuff that's going on, I don't think
Yeah.
it's
Yeah,
yeah,
I mean, there's some people out there that think, it was good that the UK's
yeah,
withdrawal from the EU.
yeah,
I disagree with a little bit, because I think,
yeah,
um, it did help us in regards to trade and things like that.
yeah,
So the impact on Brexit, it was things like the trade and the laws no longer, subject to the Court of Justice. And we don't have free movement. We've got to apply for visas now to go. So, if we were
yeah,
part of the EU, we could, so there are some discrepancies and some, impact of us
yeah,
coming out of the EU, and it did impact on the UK. So the UK governance relies on the three bodies, which is the legislature, executive, and the judiciary. And Brexit had an impact on the UK. I personally think it did. But there are people out there that think that it was a good thing, that we've opted out. But there are pros and cons of everything, things like trade and our visas, traveling back and forth and things like that, and the laws. So, they have impact on it. But it did have a major impact on the UK economy, whether it was positive or negative for some people, it did have an impact on it.
yeah,
So, what was that? Sorry.
so I'm just saying, yeah, that you're correct,
Yeah.
yeah,
It depends really how people feel about it. So the classification of law, there are areas in criminal, there are two branches, civil and criminal, which we looked at earlier. Civil produces generally with disputes between what are termed legal persons, and then, obviously the legal definition in is covering certain aspects. So concept of criminal law and concept of the civil law. So criminal law, as we explained, it's elements of that is a crime that is morally wrong. So the purpose of criminal sanction was to make the offender give, retribution, or, try to say that they won't offend. And examples of criminal law, things like murder, theft, assault, drug trafficking. And the whole concept of civil law is to try to resolve disputes between two parties, individuals, and it could be things like, property disputes. You have gone over my property. For example, it could be disputes against negligence. It could be, so here you would get a form of compensation. So it would go to court, but it's more of a relaxed kind of things. You don't get a punishment for it. So the operation of the burden of proof. So the burden of proof in civil litigation and criminal prosecutions, the burden of proof lies with party who are asserting the allegation of fact. It's a fundamental principle, and those that seek the assistance of the law must prove their claim. Both in civil and criminal law, you must prove your claim. For criminal law, it's beyond reasonable doubt, and for civil law, it's balance of probabilities. And the comparison between remedies in civil law and in criminal law. So remedies in civil law are compensation or resolving the disputes or damages. They can be awarded some damages, and the purpose is to restore the injured party. So it could be like a, personal injury claim or something. And then for criminal law, it could be things like, the punishment is to deter offenders, to try to avoid them rehabilitating them, and it could be you could get prison fines, or you could get, community service or probation. And the whole purpose is that you do that so that try to prevent the person from reoffending, trying to stop them doing any future crimes. And then you got options and the options and procedures. So for civil law, it's initiated by a claimant through a lawsuit, and the resolution is negotiations, settlements, or trials. And the role of the parties is claimant versus defendant. And the example of options is monetary damages, like we said, out of court settlements. And then for criminal law, the options and procedures are the court process is initiated by the state, which is the CPS. So for a criminal case, you take it, the CPS who works for the state is the one who deals with it. And then the resolution is trials in magistrates court or crown court, and the role of the prosecution and defendant. And sometimes it could be plea bargaining, trial verdicts, and that plea bargaining means, trying to get a plea together, to agree a plea. Table of summary. So you've got the purpose and the parties involved for criminal and civil law, okay, in that table. In conclusion, criminal law are there and civil law to try to safeguard, society and address any sort of grievances. And there are differences in how each of the law applies and how they work, but it is for the civil law is to gain compensation, of criminal law for them to stop, doing any sort of crime again, deter them. 1.4, what is crime and its impact on society? What do you think? How do you think laws impact on society? Do you think they play a big part?
Yeah, I think when there's law, you won't be doing anything silly,
Do you
so I
think
think
people
it is.
follow the law all the time?
No, not all the time, but I
Yeah,
think, especially in this country, I think there are some individuals that are following it.
yeah. It's important, isn't it? The laws, it runs through the whole of society. It guarantees our freedoms, and it's what distinguishes society. So our behavior, social order, it provides a framework for individuals to follow. And it could, it may be that you can't drive and talk on your mobile phone, and that's to prevent any sort of, accidents or anything. So it's there to protect society, and make sure that everyone is following the law. The role of role of law in society, like we said, it is there to protect individuals. It provides this framework for individuals to follow. Social order, it keeps this behavior for everyone. Um, it maintains this, it sets out your human behavior. It protects individuals as well, protection of rights. It's there for justice. So if something's done, it's to make that person accountable as well, for what they've done. And the economic stability promotes business growth, investment, and conflict resolution. So there's resolution between the courts for any sort of resolutions to um, make them peaceful. So the UK Constitution and its structure. So the UK Constitution plays a big part. We have an unwritten constitution in the UK, and the main structure of our constitution is that it's unwritten, so we could add to the law, and as some countries have got a written constitution, and our constitution is composed of laws and rules that regulate how everything runs, and together, ensuring that the rule of law and balance of power work, we're able to follow that. So going back to what we worked on a little bit earlier about the executive and the legislature, The legislature is of the UK is the lawmaking body in the UK, consisting, as I said, of Parliament, and it's the supreme legislative body for the UK and the one who makes the law. So the functions it drafts, debates, approves, and its impact on society is that it, follows trying to shape what society wants it to shape. Then you have the executive. We went through that a little bit more in detail earlier as well, just a bit more on it. So this is the Prime Minister and the Cabinet, ultimately responsible for any sort of policy making, legislation, representing in UK international affairs, and its impact on societies directly influences citizens' daily life through policies such as maybe things like, healthcare, it might be education, and it might be things like they're responsible for what the NHS do, or maybe the infrastructure of the country. So they have quite a big responsibility there. And then the judiciary, which is the final body, which is the organ of the state, and they are the judges, the ones that are responsible for the legal system, interpreting and applying the law, so resolving any disputes between individuals, businesses, and the state, ensuring that we comply with the laws as well, and making sure that we're protecting any sort. And its impact on society is that it upholds any sort of justice, equality, and the rule of law, ensuring individuals and governments are held accountable. It can't just make others accountable, it has to make sure that, everyone is accountable for what they do. So the functions in this diagram: legislature creates law, scrutinizes the executive's policies and budgets. The executive enforces laws and develops policies, proposes legislation to the legislature to approve. And how they work together is really important because, they all work together to help each other and to make things work. And then judiciary interpret and applies the law, reviews actions by executive and legislature. Function of the three branches, how they work together. So there's no separation of powers between any of the branches. They work together. There's no single power for each one. What do you think would happen if they had, if they were given the power, all of them? If one, if do you think they would abuse it?
Yeah, I think there would be a lot of conflict
Yeah.
because
Do you think they would abuse the
get
power if they work together? If they work separately, sorry, yeah. It's like America, it'll be a dictatorship. People will work, they'll get the power, they'll abuse that power, so making sure they work together. For example, the legislature drafts the law, but the executive must enforce it, and then the judiciary ensures that they apply it, uh, and the judiciary can challenge executive actions through judicial maintaining checks and balances. The impact on public society, if we have this transparent system in place, everyone's going to be happy, aren't they? Is everyone treated equally and the law's fair, they're gonna, regardless of any sort of status, if it's the Queen and it's me, Salmon, then you shouldn't be treating me differently to who the Queen is based on status. Enforceable legal frameworks encourage investment and accountability. So, government are left accountable for what they're doing. It shouldn't just be the public that are left accountable. It should be government as well for their work. And if they're not treating people fairly, so if one person's treated because of their status, then it's unfair. The law must treat everyone fairly. And that is the main principle when it comes to the rule of law. So in conclusion, it's really vital in shaping and maintaining the law. And the law plays a really vital role in society. And it provides this framework which individuals and groups can interact safely and promote justice and equality. It's also there to shape, the norms and values. I believe, without any sort of law, the society would be chaotic, they'd be like chaotic because, there'll be people that are vulnerable that are left unprotected. What do you think if the law wasn't maintained and we didn't follow these rules and regulations? Do you think there would be chaos?
Yeah, definitely, because obviously, like I said, everyone wants to do
Yeah,
what they feel like. Obviously,
yeah.
there is no.
They'd want to do what they want to do, don't they?
Yeah,
They
yeah,
won't be following any laws or anything.
yep, exactly.
It's really important that the three organs that we talk about, the legislative, executive, and judiciary, work together so that we have a democratic society and we are fair when it comes to any sort of rule of law, anything. Because if we're not fair, then we're not treating everyone the same.
Yeah,
Laws need to provide, security for people, but also a belief that, if something happens, they will get justice for that.
yeah,
It creates this legal framework. It's a set of rules and regulations that govern our behavior. So it provides a framework that we must follow. So, example again, driving whilst on your mobile phone, that is a criminal offence. But we won't do it if the laws are in place to say we can't do it. So that was looking at the laws and, for society. The next one we're looking at is the difference between common law, statutory law, and between common law and statutory law. So the relationship between common law and statutory law is crucial because it plays a big part because the two components are part of the legal system in the UK. Common law again relies on judicial decisions and precedents, while statutory law is enacted through the legislative process, creating explicit rules. So statutory law is passed through the legislation. So the definition of common law. So common law refers to the laws developed through judicial precedent, and it's developed over history a long, long time ago, and it's a body of unwritten rules based on legal precedents, and they're to guide court rulings when outcome would depend on written rules. So if there's no outcome, then people will follow common law, and common law is relying on old cases that we follow, and it's a body of law, um, and the two, how common law is they actually rely on this principle called stare decisis, which is a Latin phrase to stand by things decided. And development of common law, as we said, developed in medieval time, and judges applied consistent principles. And then the precedent and doctrine of judicial review, judicial precedent is ratio decidendi and obiter dicta. And the courts can avoid precedent in specific circumstances where you look at distinguishing, overruling, or reversing.
yeah.
Statutory law, on the other hand, is statutory law is an act of Parliament, is made by UK Parliament, and bills introduced in the House of Commons, and then it's agreed and then passed through the legislative process, and it has to get royal assent by the King to say they approve the law. You can't just say that, I'm going to pass a law, but it has to go through a process. Why do you think it has to go through a process, Samad?
Um, like so they'd know what to expect and what not to do and what to do.
Yeah, to make sure that the law is right as well. It has to go through a process to make sure, it's accessible, it's right, and that there's no breaches of the law and that everyone agrees to what they're passing. And then you've got equity and equitable remedies. Equity was developed after common law. So the reason equity was developed was because common law didn't have enough remedies, and it was introduced by the Court of Chancery, and it was developed to provide more remedies for common law, and it was remedies such as injunction, specific performance, and rescission. Whereas common law didn't have much remedies, there was a need to bring equity into place, and the remedies helped people because there were more remedies available for them, and it was there to provide the legal remedies for individuals that felt that equity wasn't helping them. Sorry, that common law wasn't helping them. Then equity was developed to provide these legal remedies. And it wasn't to replace common law, it was just to provide remedies for the courts of equity. And this was, like we said, it was by the Court of Chancery, and there are remedies such as injunctions, specific performance, rescission, declaration, rectification, so different types of remedies that were adopted, and they helped individuals. So they were there to help individuals have more of a chance of getting these remedies. Comparison of common law and equity. So looking at common law is built up of precedents, and statutory law is built up by statutes made by Parliament. So the source here in the diagram for common law is developed through judicial decisions, and for statutory law it's enacted by legislature, which is Parliament. For flexibility, evolves through case law to adapt to new situations. For statutory law, it requires formal legislative amendments. For changes, precedents, it's adopted, follows the doctrine of judicial precedent, and statutory law supersedes common law. And then examples: negligence, Donoghue, Stevenson, and the Statutory Law Equality Act 2010. Remedies in common law, legal and equitable remedies, and statutory law, typically statutory penalties or prescribed remedies that are available in that. So in conclusion, common law and statutory law are complementary and play, a big part of the English legal system. They are flexible, involve judicial decisions, and equity exactly is about ensuring fairness and bringing gaps. So it wasn't there to replace it, it was there to help common law. Together, they work together to adapt and make this common law system and make sure we have a good legal system in place. Because if we don't have a good legal system in place, nothing's going to work. So we've finished the session, and I'll just give you a summary of what we've done in today's session. So we've looked at, just going back to it, it's learning outcome 1. We've looked at introduction into law. We've looked at the history of general development of understanding how law was developed from common law, statute law. We looked at EU law. We looked at how equity and how it works in the legal system. We looked at concept of criminal law, civil law, operation and burden of proof, and balance of probabilities. We also looked at the element of remedies in civil law in regards to punishment, and what remedies are available for civil law cases and what remedies are available for common law cases. We looked at common law and precedent and development of common law, statutory law, and how it was developed. We also looked at the organs of the state, which are the 3 organs. Do you remember the 3 organs, Samad? The government organs, legislature,
yeah, the
judiciary and executive, and how they work and how they have a big role within the UK. We looked at that. We looked at the Constitution, the UK Constitution, and how everything fits together and how they function. Sorry, I've just got a bit of a cold. And we looked at an overview of the European Union. We looked at Brexit, why, why people, the pros and cons of opting out of Brexit, and also the impact of it on the UK and withdrawal from, Brexit, and what it meant for the European Union. So, in regards to trade and things like that, how it impacted on the European Union, but how it impacted on the UK that we opted out. So we looked at that in regards to an overview of everything. This is just a quick summary of what we've done in today's session. These are the references that you can rely on as well if you have any issues. The links are there, and these are the references that you could use that we've looked at for learning outcome 1. And additional resources are available on Moodle. So there's ebooks and journals on Moodle for this unit, and the reading, there's a link there that you can have a look at this document, and it's quite interesting, this document. It looks at the English legal system as a whole, looks at sources of law, which we looked at today, looks at the criminal system, the civil system, it looks at the historical development of law as well, common law and equity, and it looks at the element of EU and how equity works with the legal system. So it's quite an interesting article. So the link is there for you to have a look at. There's additional reading. The recording of this session will be available on Moodle for you as well. And all the ebooks and journals are available on Moodle. Do you have any questions, Saman, before we finish off today's session?
No,
Are you
that's all.
sure?
Yeah,
Thank you, Saman. It was lovely teaching you.
thank you
And
very much,
if you have
Adrian.
any questions or anything, email learnerwork@ukvarsity.co.uk, and submission of the assignment would be done on the same link, learnerwork@ukvarsity.co.uk. But don't worry about that, because that's after the assignment discussion session. You've got 2 weeks after you've completed the unit to do the assignment, okay?
Okay, Shadia.
Do you have any questions, Saman, before you go?
No, that's all.
The next session is tomorrow, Saman, okay?
Okay, see
So
you tomorrow then,
it's
Shadia.
at 11 o'clock tomorrow. So
Okay,
that's learning outcome 2 we'll be doing tomorrow, because we finished
okay,
learning
thank
outcome
you.
1 today and then learning outcome 2.
Okay, yeah,
Okay,
got
thank
it.
you for attending
All right,
today's session, Sam, and I'll see you tomorrow.
all right, bye.
Okay, bye.